This is the recorded lecture for Chapter 5, Crime and Criminal Law. This chapter provides an overview of criminal law, and it may be the most interesting chapter that we'll cover in this course, especially for those of you who are pursuing a career in criminal justice. After studying this chapter, I hope that each of you will be able to understand and apply the 5 main elements of criminal liability. Know some of the general limitations on the prosecution of crimes. Understand and apply the defenses to criminal liability. Be able to categorize different types of crimes. Know the core definitions of these crimes, which are listed in here, including their mens rea element and their actus reus element, and we'll go over that, as presently defined in most American jurisdictions, and how they've changed over time, because they've changed quite a bit, or some of them have. Then be able to apply those definitions to written fact patterns and identify each element from the facts that are given to you. And last, I hope you'll be able to describe and provide examples of the following concepts: crime, generally, mens rea, actus reus, mala in se, mala prohibita, inchoate crime, attempt, conspiracy, solicitation, and complicity. All right. I know this probably is a common sense definition, crime. What is crime? But we need to go through it and analyze it so that you can see all the different things that are happening, all the different things that are implied or not implied by the word crime. So a crime is a harmful act, right? That's a duh. We know that. That's common sense. A crime is a harmful act. And this bullseye graphic that you see on the slide demonstrates exactly what we mean, though. I want you to think of the largest circle. So the whole big circle. Think of that largest circle as containing all harmful acts that any human could ever do. Because not all harmful acts are crimes. So sure, crimes are harmful acts, but then there are other harmful acts that are not crimes. So that's how we're kind of analyzing what is implied or not implied by the word crime. So if the big circle includes all harmful acts, within that circle, we can categorize the harmful acts based upon what we felt like was the just consequence for them. There would be some harmful acts that would be deserving of just a simple apology from the harmful actor to the victim, such as if you bumped into someone in a crowd. So that's not a crime. You're not even going to sue them for it. You might want them to apologize, and an apology would probably be a natural response. Those are harmful acts, but they aren't crimes. So that would be sort of your exterior circle, okay? That first little layer of the onion there. Then there would be harmful acts like car accidents, or where a person purchases a product from a store and it's defective and it hurts them. Now there, you're going to want more than just an apology. You might sue them. Okay, so that's this next layer of the onion, or next circle in on the bullseye, right in here. These are considered social harms. They're not regulated by criminal law, but rather by civil law or private remedies. So the victim in that case would receive some form of compensation from the bad actor. Then there would be, in the next layer here, these are harmful acts where the act deserves, or we would hope there to be, some type of public punishment, some type of government public remedy. The government's going to get involved. Law enforcement will get involved. And those harmful acts are crimes. Starting here. Oops, didn't mean to do that. Now you see there's two little inner circles, right? There's this one, and then there's the little one. So now we're going to go look at those. We know crimes are a subset of harmful acts, but they're different types of crimes. So we're going to look a little closer at that. If you recall from earlier chapters, we had a theorist named Rene Garofalo who defined crimes as harmful acts that are universally condemned. They are acts that are evil in and of themselves because they naturally provoke moral outrage. By comparison, we might say a crime is something that is against the law, and that would be true. But saying that would be connecting the definition of crime to just positive law, to just whatever the authority figure in a culture says that it is. Well, Garofalo was looking for a more natural definition of crime. To Garofalo, natural crimes have always been and always will be crimes in any culture because they exploit. They jeopardize the evolutionary success of the human race. So here you're seeing the application of the evolutionary perspective of natural law and Garofalo's definition of natural crime. And those natural crimes are easy to name: murder, rape, assault, theft, burglary, and arson. But as I mentioned, there are more crimes than just those 6 that I listed. There are certain other actions that are not universally condemned, but may be considered crimes in some places or at certain points in history. And these types of crimes are things like prostitution. So it's a crime in most places, but not in Las Vegas and not in some other countries. Gambling is a crime in certain places, but then it's often allowed on like Indian reservations or again in Vegas and then perhaps in other countries. Marijuana use is a crime still in the state of South Carolina, but that's going to change soon, probably if you've been paying attention to the news. It has changed in some other states in our country. So these types of culture-specific or time-specific crimes are known as mala prohibita crimes. They are not necessarily evil in and of themselves, but some cultures consider them harmful acts deserving of punishment by the government or a public source of punishment. They are crimes because the authorities in that place at that time say that they are. So again, looking at our graphic, the next to the middle layer would be considered mala prohibita offenses. And the little circle in the middle are your mala in se offenses. And another way of calling them is the little mala in se offenses, or sometimes called the core offenses. They are universally condemned. And then the next layer on the outside it's just going to include all crimes, core offenses plus other harmful acts that a culture considers criminal. If you look on page 117, figure 5.1 in your textbook, you're going to see a similar graphic. And it'd be really helpful for you to study those graphics to help you kind of see clearly how crime is actually just a subset of harmful acts. Now that you see how crimes are defined as crimes, let's talk about how American society has regulated them. As I mentioned in previous chapters, crimes were first a matter handled by the common law. Judges or juries applied precedents to facts and decided whether the action was a crime. Those precedents would provide the common law definition of a crime, and the judge or jury would look at the evidence of what happened to determine whether it fits the definition. But as American culture grew larger and more complex, our government enacted legislation to codify the common law of crimes. The legislation then became the criminal code of a particular jurisdiction. A criminal code is a little more detailed than common law crimes, and it is a reflection of public policy. As public policy changes, so will the criminal code. Each state has its own criminal code, and when a harmful act crosses state lines, the federal government can get involved and prosecute the offender using the federal criminal code. There's even something in your textbook called the Model Penal Code, and that's, I think how to describe it. It's almost like a template, and states will look at the Model Penal Code and use whatever parts of it that state wants to use for its own criminal code. Crimes are handled in every jurisdiction as a harmful act against society, against the people of the community, not just the individual victim. And that's why the government takes on the job of punishing the crimes instead of it being handled just by private citizens. So the government is acting on behalf of the community when it prosecutes a crime. Now, to punish someone for a crime, to find them legally guilty, I'm not saying factually guilty, I'm saying legally guilty. 5 elements must exist. There is no exception. If each of these 5 elements are not met by the evidence, then there is no criminal liability. So these elements include actus reus, mens rea, concurrence, causation, and harm. You should memorize those 5 elements. And now I'll go through them each. Actus reus is the action element of the crime, the doing of the harm. It's mostly just, or the evidence would have to show just some type of voluntary conduct. The action just has to be voluntary conduct, as opposed to involuntary, like sleepwalking, okay? That could not be a crime because it's not a voluntary action. In some crimes, though, failing to take action is enough, such as if you fail to get a permit before you carry a concealed weapon. And in some crimes, possession is action enough. So if you possess child pornography, well, that's a crime, even though you didn't really do anything other than possess it. Or drugs, if you possess certain controlled substances, that's action enough. The next element is mens rea, and this is the mental element of a crime. And it is not the same as motive. Motive is the why of a crime, the reason for it. Mens rea is the level of intent or state of mind. Motive makes the intent more believable, but the prosecution does not have to prove motive. There are different levels of intent, and the ones that I've listed here are different than what's in your textbook. So please use my levels. They make far more sense when we come to applying these elements to fact scenarios. All right, so the first one is purposeful. Okay, a purposeful state of mind is planned and premeditated. All right, this is an action that was thought of in advance and planned out, such as hiring a hitman. The next one is knowing. These are deliberate acts, but they weren't planned ahead of time. So the gun's in your waistband, you pull it out and use it. You didn't plan on it. You had the gun for some other purpose, but it was there. You knew it, and you pulled out the gun and you used it. The next one I describe as heat of the moment intent. These are crimes of passion, as you might hear that in other places. These types of crimes are actions that happen almost recklessly, although Reckless is, I have that separate because it's handled a little bit differently in the courtroom. So crimes of passion, this would be like a barroom brawl that gets out of hand and someone gets punched a little too hard and they die. Okay. So that is murder, but it isn't knowing murder. It's a crime of passion. So it's a little bit less or a little bit lower of a level. Then you have recklessness, and that's conduct that you know is likely to cause harm, but you perform it anyway. You're being reckless. Okay. Drunk driving is reckless. All right. The next, and I guess really the last one, is negligence, although I'll tell you a little bit about strict liability. So negligence is when you fail to take action that you have a duty to perform. And you don't see this handled very often in a criminal courtroom. It's often about child neglect, although more and more now we're starting to see criminally negligent homicide in terms of drunk driving. So it is starting to be, negligence is starting to be more of a basis for criminal liability than it used to be. And I told you I was going to talk about strict liability for a second. That's a situation where you have no intent at all. There's no bad intent going on. You're liable for your action anyway. So you'll see that it mostly in rape. So we'll get to like statutory rape. That's a strict liability offense. It didn't matter whether you knew that the young lady was 14. You thought she was 18. Doesn't matter. You're strictly liable for raping her because she was underage, as a matter of fact. So that's strict liability. You don't see it very often in crimes, but I listed it on there. So I wanted you to know what I was talking about. I have transferred intent written on here, but you don't have to worry about learning that. I actually should have taken that out of the PowerPoint, but I forgot. Okay, so we've had actus reus, mens rea. Now we have concurrence, and that's pretty simple. That's when the mental element and the action element come together. So the mens rea sets the actus reus in motion. They concur, come together. Then you have causation. This is establishing that the actus reus factually and legally caused the harm. Okay. So factually, you might say, okay, but for firing my gun, you would not have been shot. So factually, the firing of my gun killed you. That's factual causation. Legal causation is an analysis of whether it was reasonably foreseeable that my act would cause harm or the harm that actually occurred. It's about proximity in time and foreseeability. And there's a really good example on page 122 of your textbook. I think it has to do with a dentist. I don't remember, but read that. If causation gives you trouble, that's a really good example, and you can see how it works there. And the last element is harm. Okay, there has to be some type of victim. So it's not necessarily going to be an specific individual victim. It can be society as a whole as the victim. And that comes into play when we're talking about mala prohibita crimes, because, there's a little bit of debate about whether there's an actual victim in prostitution, for example. I mean, we know it's harmful, but who is it really harmful to? I mean, the receiver of the services, is choosing to receive them. They're paying for it. So it's really not a victim. Or maybe there is. It's debatable. So I just want you to understand harm could be harm to a specific victim, or it could be harm to society. And it can be mental harm too, not necessarily physical. But those are the elements of every crime. For there to be criminal liability, these 5 elements must be shown by the evidence. If one of these elements is not proven by the evidence beyond a reasonable doubt, the prosecution loses and the defendant goes free. A defendant can defeat the prosecution without ever presenting a defense. He or she can just show that the prosecution's evidence fails to establish one of these necessary elements of the crime. So we were just mentioning how a criminal defendant might defend himself in court. Well, we're going to talk about a little bit more of that. So a criminal defendant can and often does present a defense. They don't have to, but they usually do. And they're usually what's known as affirmative defenses. So in an affirmative defense, the defendant is saying, yes, each element of the crime may be shown in the evidence, but, so yes, but, that's an affirmative defense. So either the harmful behavior was not actually criminal for some reason, or it was harmful and criminal, but he or she is excused from punishment for some reason. So you have a justification or an excuse. When the defendant chooses to present an affirmative defense, that's when the defendant has a burden. So if they state an affirmative defense, then they have to produce the evidence and persuade the jury that it's true. Now we'll talk just a second about what they are. So as I said, they're categorized justification and excuse. So justification defenses are self-defense, consent, and this is in the case of police officers, execution of public duties. All right, so for self-defense, we're saying, yes, my act was harmful, but it wasn't criminal because I was just trying to defend myself. I had a reasonable belief in an imminent, unprovoked attack. So my fear of being hurt was reasonable. I had a rational reason to be in fear that I was about to be hurt and about to be hurt imminently, like the very next second. And I didn't provoke the harm that was coming to me. I stood innocent in the situation. That's self-defense. Now, self-defense can be a little bit tricky and perhaps unjust. Some states require retreat from the imminent harm, but most states have a castle doctrine, meaning you can defend yourself without retreat if you're in your own home. And a few states, Florida namely, has something called a stand your ground law, where you don't have to retreat even if you aren't in your own home. We saw that happen in the Trayvon Martin case. The next justification is consent, and that's pretty obvious. Those are situations where you're in a boxing match or you're wrestling. So the victim consented to this activity that resulted in their harm. Okay. And I told you execution of public duties is mostly about the justification of police use of deadly force or harmful force. So these defenses are a way of avoiding all criminal liability for the harmful act. Yes, it's harmful, but no, it wasn't criminal because it was justified by self-defense, consent, or execution. The next category, excuse. Here, you're saying, yes, it was harmful. Yes, it was criminal, but I'm not responsible for my actions because I was under duress, I was drunk, I'm too young, or I'm legally insane. So duress in that situation, a person's act wasn't technically voluntary. So duress is a situation where the offender had no choice to do what they did. You don't see it happen very often. Intoxication, well, that's really not going to get you out of a conviction. The most that would happen is maybe your punishment will be a little lighter, but not a lot. Involuntary intoxication, now that could be a complete defense, but again, I don't see that happen very often. Another excuse is age. Okay, now that's pretty obvious. Someone who's underaged is probably not going to, like a 12-year-old who commits a crime is probably not going to go to an adult prison, right? So the sentences would be different for younger people. Then there's legal insanity, and we're not talking about mental illness. That's something different. We're talking about legal insanity. There are a lot of different tests and standards for legal insanity. Probably the most popular case you might think of is John Hinckley Jr., who shot President Reagan. Don't worry about trying to understand all those definitions. Just know that that's an excuse. It's a defense excuse that probably happens more on TV than in real life, but it is there. All right. In addition to these affirmative defenses, we want to look at the larger picture here. Our Constitution restrains government power. It limits government power by giving us due process rights. So in addition to the lack of a necessary element of a crime, possible defenses are provided by constitutional law, and they include the procedural and substantive due process violations that we talked about in connection with other chapters. There's also a constitutional limitation or defense where a crime is defined improperly. And there are these little rare situations in the original Constitution where bills of attainder and ex post facto laws would provide a defense. We're not going to get into that because honestly, I don't think it ever happens anymore. But let's look at the others a little more closely. First, procedural due process. A person can avoid criminal liability because the prosecution violated the due process guarantees found in the 4th, 5th, or 6th Amendment of the Constitution. For example, the 4th Amendment's search and seizure rules. A defendant can show that evidence of some necessary element of the crime was illegally seized and therefore is inadmissible, so no crime can be legally proven. Some may refer to these defenses as technicalities, but they're valid defenses. They exist because our government exists to protect our fundamental rights as free citizens. We saw an example of that in the Brewer versus Williams case that we studied. Williams successfully argued that his confession was illegally obtained outside the presence of counsel. The right to counsel is a fundamental right guaranteed to all citizens. We'll look a little more closely at these procedural due process rights when we cover the next chapter, but for now, just know that they are a defense to criminal liability. Next are substantive due process guarantees. Now, we saw these defenses at work when we studied the Loving versus Virginia case. The Lovings defended themselves against the anti-miscegenation law of Virginia because the law deprived them of their substantive right to marry whomever they pleased. These defenses are not based upon the conduct of the prosecution. They're based upon the wrongness of the law that defined the conduct as criminal to begin with. So these defenses are based upon the equal protection and fundamental rights guarantees of the 5th and 14th Amendments. There may also be a defense based upon the way a law is written. A person cannot be liable for violating a law that is written too broadly or vaguely. And honestly, I've never heard of a case where this happened. But governments are held accountable for the way they define a crime. It would be an abuse of prosecutorial power if a law was so vague that just about any behavior could be deemed criminal at the whim of the government. Last, there are defenses available to the type of punishment that is imposed. So these aren't really defenses to criminal liability, but they are important to understand. The Constitution prohibits cruel and unusual punishment in the 8th Amendment. For example, we do not execute people for stealing. We no longer execute by hanging. It is unconstitutional to execute a person who is mentally disabled or under the age of 18. Right now, the South Carolina legislature is considering whether to bring back the electric chair and firing squads as a means of execution. The U.S. Supreme Court has never ruled that death by the electric chair or firing squad is cruel and unusual punishment. So this is still a matter of public policy and will be handled through the legislative process for the time being. The legislative measure being debated now in South Carolina, just so you know, it's because of a shortage of the drugs that are used in the lethal injection process. The companies who make these drugs do not like the fact that they're being used in the execution process, so they're limiting access to them. And the practical consequence of that shortage is that executions are delayed and because the drugs are unavailable. And so that means for some, justice is delayed. And the South Carolina legislature is proposing alternatives that include firing squads or the electric chair so that those executions are actually carried out. But that moves closer toward the debate over execution generally, which isn't something that we have time to study right now. All right, now we're going to talk about crimes, specific crimes. As I go through each of these crimes, I want you to pay very close attention to how each of the 5 necessary elements might be established by the facts. We're going to move along yet another continuum of most egregious crimes to least egregious crimes, from mala in se to mala prohibita. And you'll notice that as we do that, we move from crimes against the person to crimes against property to crimes against the moral order of a society. And that's its own little typology. All right, murder. Okay, at common law, murder was defined as the killing of another with malice aforethought. So the actus reus was the killing, and the mens rea was the malice. Now, however, we have a legal code that defines murder in much greater detail, with varying degrees of mens rea or levels of culpability. We also have to be aware of certain questions about whether and when a person is killed. Okay, so as far as person goes, some states now define an unborn fetus as a person for purposes of criminal liability for murder, but some states don't. So there's state to state variation in who or how person is defined for purposes of murder. There's also the tricky situation of when a person doesn't die immediately, but remains on life support. And a court has to determine whether the act is assault or murder. So when is a person dead or killed for purposes of a murder statute? That's also subject to some debate and variation among different states. All right, we're going to look now closer at the levels of mens rea or levels of culpability. And this is in connection with murder specifically. So thanks to the criminal code, we have very carefully defined levels or degrees of murder based upon the level of intent held by the actor. And these levels should look familiar to what we went over earlier. So there's first degree murder or premeditated murder, murders that are planned in advance. And I really like the movie Shawshank Redemption. You need to watch it if you haven't already. And I'm going to use it as an example. So in Shawshank Redemption, the main character played by Tim Robbins was Andy Dufresne, and he was convicted of first degree murder. And you see a picture of him there. So he's sitting in his car just brooding because he knows that his wife is having an affair in the act right now or right there in that scene. And he's got a gun with him and he's sitting there planning in advance how he's going to go in and shoot her and the man she's with. Okay. That's first degree premeditated murder and also purposeful intent. That's the most egregious form of, or most egregious state of mind, purposeful. The second one is second degree murder, where the murder was intentional, but it wasn't planned in advance. So that's knowing intent, knowing murder. And then there is voluntary manslaughter. That's a situation, again, where a person dies in a fight, like a heat of passion. A person knows his or her conduct is likely to cause harm, but doesn't really mean to kill anyone. Here she's just really angry and violent and winds up killing somebody. That's voluntary manslaughter. Their actions were voluntary, but they were not known. Like you know that it's going to cause harm, but you don't really mean to kill anybody. The next is involuntary manslaughter. And this is recklessness or reckless intent. An example was seen in the case of Michelle Carter. That's the young lady pictured on the slide. In that case, if you aren't aware of it, I think it happened in Texas. Michelle Carter, through a series of text messages, induced her friend to commit suicide. And the prosecution admitted evidence of all those text messages and established the crime of involuntary manslaughter, conduct that was taken without regard for the consequences. So Ms. Carter is now in jail, although she's set forth many, many appeals over whether her conduct is criminal or not. But involuntary manslaughter is conduct taken without regard for the consequences of their actions. The next is negligent homicide. I mentioned that a little earlier. This is where you fail to perform a legal duty and it results in death. So this might be a situation where, for example, a parent leaves a child in a car and they die of heat stroke, right? So you have a duty to protect your child. So it's child neglect, perhaps, that results in death. The last one I have on here is called felony murder. This isn't a level of intent. I just wanted to put it in there so you were aware of it. Felony murder is murder that occurs during the commission of an entirely different crime, usually burglary. So a burglar is inside the house stealing, and they encounter the resident and wind up killing the resident. So that isn't just burglary, that's felony murder. It also happens like the robbery in a robbery of a convenience store where the robber winds up shooting the store clerk and killing him. All right, next is rape. So the common law definition of rape is this: carnal knowledge by a man of a woman, not his wife, forcibly and against her will. Now that definition reflects a very outdated perspective of rape, of gender. And it provides us with a really good opportunity to see how the law has changed as our values and norms and beliefs have changed. Now, rape, like other crimes, is codified. It's a form of assault. And the two main elements, mens rea and actus reus, are where the different types of rape are taken into account. But at common law, the actus reus of rape was the penetration of female genitalia by male genitalia, right? Carnal knowledge. That's what carnal knowledge means. Outside the scope of marriage and with force. So oral or anal sex was not rape. A man could not be guilty of raping a man. A husband could not be criminally liable for raping his wife. So the common law definition reflected an archaic belief in a man's conjugal rights to his wife. And rape had to be forced. So it couldn't be a situation where a man drugged a woman so that she would be unable to resist. So as far as mens rea went with the common law definition, it was just focused on the intent of the victim. Was she willing? Did the guy have to force himself on her? So the evidence wound up being focused on the behavior or the dress of the victim, of the woman. Now, fortunately, the law has changed to accommodate reality and equality. So now the actus reus in most states is simply unwanted contact. unwanted contact of the sex organs. Okay. It's also known as assault or criminally sexual criminally sexual contact. There is no gender element in most jurisdictions, nor is there any difference given to the marital status between the offender and the victim. Force is not an element connected to the actus reus. Force only comes into play with the degree of rape, like first-degree rape or second-degree rape. Rape can happen even where there is no physical resistance to the contact. If the offender lacked the consent of the victim, then the actus reus element is satisfied. The mens rea element is the offender's intent to make contact with the victim. The focus is on the offender's state of mind, not the victim's. These changes from the common law to the codification of rape reflect a dramatic change in public policy, and is an example of law changing to accommodate changing values, norms, and beliefs of the culture, which is something we studied in Chapter 1. Next, we have assault and battery. The definition of assault used to be more akin to attempted battery. So where battery would include the actual physical harm, and assault would mean the mere threat of harm. But now they're combined as a single crime with the absence of any actual physical contact would just alter the crime of one of attempted assault and battery. So the actus reus then is the unwanted physical contact, like I said, in the case of rape now, and the mens rea is the intent to make that contact. The crime is graded based upon the severity of the harm and the use of force or weapons. There is some blurring of the line between aggravated assault and murder. As I mentioned in connection with murder, sometimes a person is killed in the midst of a fight. The death may not have been intended, only the physical contact. But when death occurs, the crime is murder with a lower level of mens rea. The reverse may be true in some jurisdictions. A person intends to murder someone, but the victim is only hurt and he or she never dies. Then is the crime attempted murder or aggravated assault? The intent to kill carries with it the intent to make harmful physical contact. So the element of mens rea may be present, only the harm caused different. So it's just a little blurry there, and it makes for a good fun discussion or exam question. Next is robbery. And this is the last crime against the person that we'll study. Robbery is the taking of property from the person of another by force or threat. It's not just stealing property. It's stealing property or stealing from the person of another. So it's stealing property from the person who owns it. So it involves this potential for personal injury. That's what makes it a crime against the person. The mens rea is the specific intent to take the property from the person of another. Extortion is similar. It's just robbery through threat of future harm. All right, next, now we're in crimes against property, okay? So theft. Theft or larceny is the taking and carrying away of the property of another with the intent to permanently deprive the owner of it. Notice the distinction between robbery and larceny. For larceny, the offender's actus reus is different. The taking in larceny is just that, taking property that isn't yours. There is no potential for physical harm to a person involved in larceny. So if you're taking from a person, it's robbery. But if you're just taking property and there's no threat of physical harm to the owner, it's simply larceny or theft. Larceny is often classified or graded with degrees by the value of the property and the means of taking it. It is defined very broadly now because technology provides very many means of theft and very many different types of property. So it's going to apply even when the offender has only very brief control over the property, and even when the taking is very, very slight, like a very slight distance. Next is burglary. Burglary is the forcible entry into a structure with the intent to commit a felony while therein. So the mens rea is the specific intent to enter and commit a felony. So both intend to enter and commit a felony while therein. That's the mens rea. The actus reus is the unlawful entry into any structure, and it does not have to be occupied, but that might make the offense be graded higher. The concurrence is very important in the crime of burglary. The intent to commit a crime must exist at the time the offender enters the property. They have to come together. All right, next is arson. Arson is the setting fire to a structure with the intent to burn it in whole or in part. So the mens rea is intent to burn, even recklessly, but not negligently. So it's not negligently setting a structure on fire. You have to either intend, purposefully, knowingly intend to burn, or you recklessly set fire to a structure. That's arson. And the actus reus is the setting fire, that action. So the mens rea is purposeful, knowing, or reckless intent to burn, and the actus reus is the actual burning in whole or in part of a structure. And it's the occupancy of the structure is just going to affect whether how the crime of arson is graded. So it doesn't have to be occupied for it to be arson. It can be an unoccupied structure. All right, that's the last crime against property, and we're going to end here. Well, we're almost done. The next one is crimes against the public order or crimes against morality. So we've reached now the opposite end of our little continuum of egregiousness. We've moved from the crimes of murder, where a victim dies, to crimes that may or may not have a specific victim at all. And remember I said a crime doesn't have to have a specifically identifiable victim. It can't, the harm could be caused to society as a whole. And this is where it happens, crimes against public order. These are not Malin say crimes at all. So there's a much lower consensus as to whether the behavior should be punished. Sometimes we must admit that these offenses are themselves an act of injustice because they are used to dampen the political action of minority groups. Sometimes these offenses are meant to make people more comfortable, even when there is no actual threat to the safety of the community. So as a result, these crimes are often challenged as violations of fundamental rights, the freedom of speech, namely. And some common examples of these crimes against public order are breach of the peace, fighting, playing loud music, public drunkenness, unlawful assembly. So breach of the peace, unlawful assembly. Okay. During the civil rights movement, those types of laws were used to silence the activists. A lot of the people who were put in prison in Colombia in the 1960s, they were imprisoned for violating the laws for maintaining the peace and order of society, right? Breach of the peace. And the laws were challenged in the U.S. Supreme Court and found to be a violation of their civil rights. Then the other ones where these are laws that really just make people more comfortable or maybe based upon religious beliefs, such as prostitution, sodomy. Now, sodomy laws are no longer valid because of some U.S. Supreme Court decisions, but there used to be laws that prohibited sodomy. And then also drug use, sale, and distribution of drugs are also considered crimes against public order. All right, so now our last is the inchoate crimes. Inchoate, I think, means incomplete. So it's sort of a misnomer to call these inchoate crimes because they are crimes. Okay. It's almost like it's the first half a crime to get started on a crime, but it is an actual crime that you can be punished for. So don't let that trip you up. They are attempt, solicitation, conspiracy, and complicity. And we'll go through. I want you to make sure you know the mens rea and the actus reus element of each of these. So attempt. Attempt is the specific intent to do a criminal act plus some step in furtherance of that act. So it could be, for example, walking up to a woman in a dark parking garage with a rope in your pocket and a gun in your hand. Okay. You know that that's about to be an abduction or maybe even a murder, but that act, that step in furtherance, the walking up to a woman with a weapon, can be a crime in and of itself, an attempt, like an attempted kidnapping or attempted murder, perhaps. The next is solicitation. Here you have the specific intent to induce another to commit a crime plus the words of solicitation. So the asking. When a woman meets a hitman at a bar and asks him to kill her husband, she has committed the crime of solicitation. The next is conspiracy. Here we have a specific intent that a crime should occur plus an agreement. So conspiracy must have an agreement between two or more people who intend that a crime should occur, plus an act in furtherance of their agreement. So conspiracy as a crime is often used to regulate gang activity or criminal organizations like the mafia. That's why I have pictures from the two absolute best mafia movies, Godfather and Goodfellas. That's on your slide there. All right, the last one is complicity. Here you have liability for acting together with other criminals. So a person can be complicit in a crime that they don't completely carry out. So if you give any support towards a criminal offense before, during, or after it occurs, you are complicit in the crime, such as hiding the evidence, driving the getaway car, or as in Goodfellas, burying the body, or providing weapons. Okay, so that's the end of the lecture for chapter 5. You can proceed now with your other assignments.